Hello, if you haven't done so, please subscribe and hit the like button. I want to do a quick update on Letecia Stauch and then a very brief update and then talk a little bit about Daybell and Vallow Chad Daybell and Lori Vallow. First, on Letecia Stauch, these are new documents, that were dropped today for the second competency testing or evaluation. So Ms. Stauch, through counsel, requests a second competency evaluation. And then it says they've contacted Dr. Jackie Grimmett to conduct the second competency evaluation, and that Dr. Grimmett has agreed to do that. And then it goes on to speak about, Dr. Grimmett estimates that conducting the second evaluation with Ms. Stauch, reviewing the records and writing the second competency evaluation will take approximately 20 hours. So she will be getting that second evaluation very soon. And I think this right here, it just kind of sums everything up about the second competency evaluation. And then let me look. Sorry, my eyes are bad with this screen. All right, sanity competency evaluation. So defense requests release of video recording and court request parties to brief the issue. Defense requests that next evaluation not be recorded. Open and brief due September the 28th of 2020. Response brief is due on October 16th of 2020. Reply brief due by October 30th of 2020. Autopsy report has been received by both parties. Parties are ordered not to view thumb drive of CMHIP interview provided to both sides in the court. All right, and that's it on Letecia. Like I said, very brief, just that it has been set up for her second competency evaluation. Dr. Grimmett will be performing it, and we'll see how that goes. Now let's move on to Chad Daybell and Lori Vallow. And this, I've actually subscribed to Lori Hellis. She's a criminal attorney, and she's very thorough, and she breaks down pretty much in layman terms to where, humans like myself who are not that familiar with all of the different laws, she puts it out there so that we can comprehend it. We know what's going on. We know what to expect. We know if it's normal or not. So I've subscribed to her newsletter, and this is a newsletter that I think I actually received it today, but I do include her email at the end. So if you're following the case and just want to know just the basic information, but where it's understandable, definitely subscribe. I mean, she's a good writer, and she knows what she's speaking of. But I want to read what she has put out. And again, it's Lori Hellis. And then she, in her article that she's written up, under Idaho law, cases are appropriately, and this is talking about the Joinder, to where, if you remember, I think it was last night that we heard Lori's attorney did not object to the Joinder, which Chad's attorney did. So it's going to be really interesting to see how that plays out, but she's touching base on that. So under Idaho law, cases are approximately joined when the charges and the evidence are the same. Chad and Lori's charges are different. If you guys remember, Chad's being charged with a whole lot more than what Lori's being charged with. And here's all of Chad's charges, and I'm not going to go through them all. If you guys want to just pause and see all of the charges that are under his name. But then she goes on to say, for every criminal charge, there are elements that the prosecutor must prove. And then she goes on and she lists the elements. And again, just pause through it, read that, the charges, and then what has to be proven. And she says, as you can see, what the prosecutor has to prove is very different in both crimes. The prosecutor has to prove all this against Chad, but only the second part as to Lori. Thinking it through, Lori could be found guilty of conspiracy based solely on her text messages and the fact that Chad bought duct tape. There would not necessarily need to be any discussion of the actual way the children's bodies were destroyed, concealed, or altered. But to prove the first charges as to Chad, the prosecutor will have to bring in all the evidence about the condition of the evidence, the children's bodies, and how it came to be in that condition. That's very emotional evidence. And it's possible a jury could find Lori guilty on her charges based on the evidence presented to prove the charges against Chad. That is why defense attorneys oppose joint trials, and that is why I think Mark Mean should have opposed the joinder of the trials, in which I think we all know believe, or I do at least, that he probably did want to object. And I think Lori's the one that obviously has the main say, and she kind of vetoed no, she wants to go for the joinder. So back to Lori Hellis's article. Although Mark Means may vary... Oh, well, I guess I just said that. I'm sorry, I just quickly read through this. Although Mark Means may very well have done the same analysis and may have advised his clients to oppose the joinder, ultimately an attorney is ethically bound to follow his client's wishes. So why would Lori want the trials joined? Many people have speculated that it is because she wants to see Chad and be in the courtroom with him, dressed up pretty. That could be one reason. And then Lori says she personally believes that Lori sees it as her responsibility as a faithful wife under the doctrine of the Church of Jesus Christ of Latter-day Saints. And I have to say, I do agree with that, because they're really into the religion. But to defer her husband in all things, even in trial. In the LDS faith, now this is interesting. In the LDS faith, wives are subject to their husband's, quote, priesthood in all things. Wives only obtain the resurrection through, resurrection and exaltation to the celestial kingdom through their husbands. That is why it's so critical in the faith for a woman to marry. According to the LDS Journal of Discourses, no woman will get into the celestial kingdom except her husband receives her. If she is worthy to have a husband, and if not, somebody will receive her as a servant. A woman's salvation is dependent on her husband's priesthood authority, which he receives when he is endowed with the keys to the, is that Aaronic priesthood? In a ceremony at about age 12, girls do not receive priesthood authority. They can't be saved unless they are sealed to a male who has priesthood authority. So that's really interesting. I've never really read much on LDS. I'm aware of them, of course, but I didn't know any of this. A husband's priesthood authority gives him a greater connection to God and a better opportunity to discern God's will through personal revelation. Lori's traditional LDS belief in her place as a wife may be what led her to direct Mark Means not to object to the joinder, beyond wanting to sit in the same room with him. Lori believes it is his right and responsibility to direct their legal process. Her view of Chad as the prophet further amplifies her desire to defer to him in all things. That may also be why John Pryor's objection to Joinder was so tepid and toothless. He may have felt his response was a compromise, allowing him to preserve an objection for appeal while honoring his client's wishes. And the next, which that's very normal, as far as the motion to permit street clothes. That's something, obviously, if someone walks in there, the defendant in their jailhouse attire, the jurors, they're going to label them. So it's definitely not out of the ordinary for anyone at trial, a defendant, to wear their street clothes per se. And then, of course, the cosmetics and hair products, again, that's normal. Okay, and she does say that's a very typical sort of pretrial motion. And I agree. I do also believe Lori's very concerned about her appearance. And of course, Mr. Means is concerned about the jury's impressions. And then she just goes on to say pretty much what I just said about how the jury would view her on a subconscious level and jump to conclusions. All right, and then let's see, it goes on and she says it appears that a hearing on pretrial motion, sometimes called an omnibus hearing, is scheduled for October 29th, 2020 at 9 a.m., except for the hearing on the motion to change venue, which is scheduled for November 24th, 2020. And then it appears that Lori's trial date has been moved up from April to March. And of course, that'll change if it's joined with Chad's. And again, this is from Lori Hellis, and she's a criminal attorney, and her information is at the top there. And I would highly recommend subscribing to her newsletter.